to approve our agenda. Make a motion to approve the agenda.
Sure. I motion to approve it.
Okay, I'll second. Amy, are you good with the agenda as it stands?
Yes, I am.
All right, perfect. So the next part is just the call to the audience. Hilda, are there any public comments?
No, there is not.
Okay, so then I'm going to go ahead and move to our rolling notes. So the plan today is to go over the 5306, the A and B, so the expulsion and suspension policies. And then maybe we'll get to the staff interviews and the outside stakeholders interviews. So hopefully we kind of already did this homework, but just in case, just getting through the interviews for the police and Department of Child Services, or whatever we call it now. Anybody have any questions or anything about those things that we were working on?
No.
Does anyone need to just take like 5-10 minutes to go through it? Actually, I see everybody has comments, so we might be able to just go ahead and move through.
I feel good with the 306A.
Okay.
We really need a couple minutes before we looked at 306B.
Okay, so let's just go ahead and start with that one. Let me just make sure. Okay, that you see. So now it's going to be kind of the same process we did last time. So it'll just be like first person's comment. We'll go ahead and get started. So Amy, you're the first one.
I remember looking at this one and just thinking that the language was a little bit confusing on it, because and I'm not looking at the document because I'll be home in like 2 minutes. I'm still driving. But it was just a little bit confusing the way that it was worded. And I don't know if it's just because of the way the layout is, or if it was just like my processing of it. But it was talking about like, you can't do this, but it must meet this criteria, but not that. That's where I was just a little, I understand what it's saying because I know the law, but I just wanted to be a little bit clearer.
Yeah. I think last time too, this is like straight out of whatever the state policy is for statute. I'm not sure what to do about that. Jay and Katie, what do you think? Should we?
I mean, honestly, if it's state statute, I just maybe, and it was just me trying to process it. It just seemed, I don't know, because this is the one where it talks about like you have to be this age, but you also have to meet this criteria. But unless it meets this threshold, is that the correct one?
Yeah, and it really is kind of just copied and pasted from the law. The law was updated last year or the year before or something like that, and that's been reflected here. It's basically saying you can suspend a student that's over the age of 7 for these specific things, if all these other things are met, basically. So like if you know, yeah.
And this is why I'm not a lawyer.
So yeah, it really only applies to students who are, the rest of everything after number 1 only applies to students who are over 7 years old. And remind me, Jay, was this younger or older before? Was it 8 before?
No, it was, we never had a limit. 7 became like the new limit before you could like.
Sorry, I didn't mean to cut you off, Adriana, but there was a time when there was no limit. But then they put a limit in place, and I think it was through 7 years old with no caveats for there are circumstances where this can happen with kids who are 7 years. Sorry, there was nothing, and then it was K through 4, but then they wanted to add the language that if they were 7 years or older under these extenuating circumstances, you could. So 3 or 4 years ago, they put a statute in place that said you can't do these suspensions for any kid kindergarten through 4th grade. And then there were some situations that arose with kids and firearms or narcotics where those kids were older than 7 and in K-4, and those got a lot of publicity, and then they went back and they adjusted the law again. And I think you're right, Katie. I think it was last year that the new law went into place, but it might have been 2 years ago.
So I think what we're going to end up doing is leaving it how it stands. And then since it's just copied and pasted from the statute, does that work for everybody?
I'm totally fine with that.
And then, okay, so the next comment was me. I'm pretty sure my only thing was just that we call it a hearing. And I think when I hear hearing or read hearing, I think like something very like, even though it says informal, it just is a weird word to use where I think like would conduct an informal meeting would maybe fit better, especially because there'll be hearings later on for like long-term suspensions. And so I don't know. That was my only thing. Like, is hearing kind of a misnomer there for what we actually do?
Yeah, no, I made a similar comment on that same section, just the phrasing of like the informal hearing and then the principal orally informs the student of the behavior. I don't know. I just wasn't sure if it's like, if there's something about it being like a verbal or why the stipulation of like it is informed verbally in a hearing. I don't know. I was curious about that as well.
Yeah. Well, and that's why, especially because orally inform the student of the alleged behavior is considered a violation of the rules. Could not respond. Yeah, especially because I think too we do like we have the meeting with the parent, and so like usually you do tell the kid first, but then you end up having a parent meeting. And so even where it's like, and the student's parent or legal guardian will be notified, well, that's when we require like a meeting to get the paperwork done. So okay, so can we start? Let me start with this. Do we want to delineate a meeting versus a hearing, or should I just make those synonymous in my mind and move on?
So the reason why you need to have this language in formal hearing is because of just like administrative law. So those are like the key terms to show that you're giving somebody due process when it comes to like administrative law stuff. So I would leave it as an informal hearing.
Okay, so then you're orally informing the student of the alleged behavior. The basis
The
of
orally thing is the only thing I can think of for that, because it's not actually based in the statute, is that they just don't want it in writing. I mean, the less you have in writing, the better, legally speaking. I don't know the intention behind that.
And Adriana, can we note that James joined the meeting at 4:41 p.m.?
Okay. Hi, James. We just are looking at the student discipline. So if you go to the rolling agenda, if you just click on 5306A, I think we're basically on page 2. Yeah.
Thank you.
I don't know why I don't ever put page numbers on these. Okay, so we got to keep the hearing, and then so let me just clear that. And then going back to what you were saying, Evan, I feel like this is the like starting of like the investigation. I don't know if we want to. Well, sorry, actually, Katie, do you suggest that we keep, with the exception of like discussing this orally, we keep the rest of this the same as well then?
Seems interesting. Well, the one interesting question I have is, the principal will orally inform the student of the alleged behavior, but then it says the student will be given an opportunity to respond. Is that also orally or in writing? I don't.
Well, so that's why I'm saying that feels like that part is actually more of the investigation part. Oh, let me start over. How we have like kind of classified it for ourselves is like, we hear about something, we let the kids know like, hey, we heard that you did this, there's a violation. And here's like a statement form that you need to respond so that they give their side of the story, or like basically how they shouldn't get in trouble is what it ends up being.
Yeah.
So I think that's what that part is. And
Mhm.
then what we probably would have called the informal hearing is when we would like then be like, okay, now we're ready to tell you these things. And that's when we notify the parent. So
Okay.
I don't know if we need to like delineate that like the principal will conduct or the principal or the designee would conduct a like an investigation, including giving a student opportunity to respond. So we like make it a little bit clearer that that's like the investigation part. Because what we don't do is we don't say, okay, you're going to get suspended 3 days for a fight. Here's the suspension paperwork, and then tell them like, oh, you can respond to me now.
Well, the other thing that's weird about the way this is written is like, it says that prior to a short-term suspension, the principal will conduct an informal hearing, but then we're like jumping the gun by saying that and then having all this after that, because I assume all this takes place before the informal hearing.
Yes.
Okay, so I feel like rearranging this wouldn't be bad. It would make more sense, like y'all are saying.
Okay. I think where it has, oh, I'm not sure what's happening there. Sorry. That go away. I'm on the wrong thing. Where it says informal hearing right here, I think if we change that, we'll conduct an investigation.
Mhm.
And then like we'd be like, during which the principal will orally inform the student and give them an opportunity to respond. And then following an investigation, if the principal determines a short suspension is appropriate, an informal hearing will occur
Mhm.
where the
Well,
suspension.
they also have. Oh yeah, and then this is interesting down here. It's like the okay, sorry,
No, you're
sorry.
good. And then
Yeah, I think that makes sense. Following the investigation is I'll hold a short informal hearing.
you think that we need to delineate like the principal or principal designee, or I guess it's up here, a building principal or other designated administrator.
Yeah,
Okay,
I think
so
if you just put principal, then that's fine. As long as you have that up there.
um, if the principal determines that a short-term suspension is appropriate, this was appropriate, an informal hearing will be conducted. I got too many commas kind of floating around in here. What do you think about that? If everyone wants to look at these from during which to the end of that second one.
Say that again?
Are you still driving, Amy? Because then I probably
No,
should
I'm
read
at my house now.
Okay.
So I can see my face.
I was just saying, I started like, so if you read the next two paragraphs, does that make more sense in terms of what we actually do? And should we add or take anything out? Also, there's a lot of comma clauses happening, so somebody may want to double check that too.
I feel like that makes more sense to me and feels more like the steps that we are currently doing.
And I see what you're saying about hearing. I feel like it should be an investigation.
Yeah. So we just changed it here, but I brought it down here so that you do see that there is an informal hearing. Do we need to move this? Do we need to put this no appeal process up here? Like we notified you and you can appeal. And then here are like some random things that may also happen. Or just, thoughts?
Say it one more
I
time.
think
I was
so.
rereading.
I think it's okay there at the bottom.
Okay.
Yeah.
Yeah, I think it's fine at the end.
All right. And then next one is Evan.
I think we're all talking about this same like couple of sentences here about the written notice for the long-term suspension. Just
Yeah.
I don't know, it's not, I think, something that happens very often, but
There used to be a official letter that we wrote and like through certified mail and sent it.
Uh-huh.
mm,
But that was, guys, that
I've
was a
never
while ago.
Okay, so let me see if I can.
We still do that. We still have to send a certified letter for the hearing, and there's like a 10-day limit.
I can look in the shared drive for the APs and see if it's there.
Is there a specified form or is that letter enough?
Typically, if it's going to a formal hearing, it comes from Yesenia. So it's typically handled at the district office.
Hmm.
Okay, so maybe that's why we don't know about it.
Yeah. Hilda, when you gave us a while back, you gave us like a link to the forms that the trust has, because they're not on the like actual district website. Do you still
Mhm.
could you send that link again?
Yeah, let me look for it and then I'll send it.
And then what I'll do is I'll link it to the rolling agenda. Because I wonder if they already have a written notice of intent. So basically we just leave this then, right? Because we'll use the one the district has.
Yes,
Okay.
for the process that we already follow as a district.
Yeah. Okay. And then I just deleted this and then I saw Amy added a comment. Do instead of it was back to the principal or principal designee. Do we want to do administration?
Yes, please.
Mhm.
Maybe I should match it up here.
I think that was throughout. There was a lot of like, it was principal, principal, principal rather than administration.
Yeah. Oops, apparently I don't know how to spell it. Okay. And then I don't know, do they have to be mailed or
I
Well,
think
the-
they were always done certified mail to show that we intended. We could give them like, so that way it was given to the recipient and that we had attempted and that that was
Yes.
signed for.
It also says right here, or hand delivered to the parent or legal guardian at the last known address. I mean, it's kind of like serving somebody basically.
More or less. And we've even had people request to come to the district office to get them. We had a lady earlier this year who wanted to expedite the process. And so she offered to come to the district office. So as long as they sign, they need to sign in some way that they've received it. And so certified, if it's being mailed, certified is necessary. If it's not being mailed, then obviously we can just capture a signature.
Okay. All right. So then the next one is about the long-term suspensions, but also like the whole mailing and hand delivered. So I think no less than 5 working days prior to the hearing. Close. Okay, so I think that's the same thing. So I'm going to clear that one. And then I don't see, oh wait, no. So the next one is restrictions during a period of long-term suspension. Suspended students shall not be permitted on district property and shall be permitted to participate in district functions or activities. Oh, I do think we did have district-sponsored events in the previous one. So I'm guessing, Amy, we would like add it here probably. District functions or activities on and off district property.
Something on the lines of that to make it a little bit more clear. And the reason for that is because I've been supporting some sites with like where we have had to handle different situations. So that's why it made me think of like the language behind that, where it was like district sponsored events, or so it's like if someone shows up during like the turkey trot, but they're not supposed to be, is it, you know, kind of, so that just made it very clear. See what I'm saying?
Yeah.
Or was I not clear on that?
No, I know what you mean. I was just trying to, because I think that happened to us once too. Like they well, they weren't technically suspended, but they weren't allowed to go to like a Perry Park field trip, but then they like showed up on their own to Perry Park, or like we've had kids who like magically just are absent from school but happen to be at the Harkins field trip. You don't know.
Mm-hmm.
I just added on and off district property. Does that work?
Yeah.
So the other one is mine. I wasn't sure. We did a thing last year. Remember, James, where we met with Tyson and we had to go back and make those corrections on our suspensions, where we were labeling like whether kids who were suspended were receiving services, like our students with IEPs. So I just wasn't sure, like this feels very certain that no assignments for suspended students will be provided. Does that also include like our students with IEPs and their service minutes, or is that just something different?
Well, I think it depends as long as you're within that window. And if this still falls under long-term suspension, then if it's more than 10 days, then they're required to do like a manifestation hearing and get their services.
That's
So I don't think it would include students with IEPs because they still have to get those services. It might just come in a different, like an alternative setting, like ACEs or something on the lines of that.
Okay.
I am wondering though, because the next line says, I didn't even notice, the student will receive no credit for the semesters during which the long-term suspension was imposed. But if it's like an 11-day suspension, that means that we like are also canceling out 35 days where they did show up for a quarter. So I'm wondering if like we either need to say that like if a student is suspended for more than 50%.
That also says the semester, not just a quarter.
Yeah. So
wow.
So do we want to, so I guess that's the first thing. Change it to quarters, like it based on the quarter. And then how much of a percentage of the suspension would, let me try that sentence in a way that might make sense. What would be the percentage of the quarter that would need to be missed as a result of a suspension for us to think that there really would be no way a kid could get credit for that, could get grades for that quarter? Isn't it, it's 10%, right? For the chronic absentee, it's 10% of the 180 days. So, 5 days. Okay, so it needs to be more than 10% because I feel like that's not even a long-term suspension.
Yeah, this stuff in here is not a part of the statute. So like whatever we think is appropriate is what we should do. And I would say I agree. Like I wouldn't, I don't think the board would want somebody who's been there for 80% of the semester and misses like the last 2 weeks to not get any credit.
Yeah. I feel like if we even did like,
And then sorry, and then what happens if they're like in 8th grade? Like,
or
Yeah, they don't get promoted or something. That's crazy.
yeah. Well, if we did, so 23 days is 51% of a single quarter. Because I feel like if you've missed, I would say if your long-term suspension is more than 20 days, you should not receive credit for the quarter.
So yeah, so you're saying to add that to the beginning of that one sentence.
Yeah,
If the long-term suspension is more than,
yeah, that's what I'm thinking. Oh, and I lost where we're at.
I have a question. Can everybody hear me?
Yep.
So I'm curious about because I was a part of a long-term suspension just recently, and my understanding is that when something like this comes along, when something like this comes along, it's typically something that is for like a quarter or a semester. I mean, maybe Mr. Mann can clarify some of this, but does I mean, a principal has the ability to go and suspend a student for less than 10 days, and they can do that theoretically. I mean, it's not recommended, but theoretically they can do that intermittently for an extended period of time if they wanted to. I would hope that that's not something that would take place, but they theoretically could. But with something like a long-term suspension, I mean, I don't know the history of it. From what I was told, that it had been a couple of years since there'd been a long-term suspension, and they're not typically something that is 10 days, 15 days, 20 days. It's typically a long time. But I mean, I could be wrong. Maybe Mr. Mann can clarify, or somebody else can clarify.
Well, I'm just thinking in practice it probably is, but in our like parent compact thing, it says more than 10 days. So an 11-day would be considered a long term.
Right.
But I don't know. What do you think, Jay?
This honestly is something that happens with relative infrequency. Like it has to be something really severe, like a kid, was brandishing a weapon at other kids, or beat a kid nearly to death. I mean, these are like really extreme circumstances where these things typically occur. But one thing I need to clarify is I don't think a principal can intermittently suspend, because there is a maximum number of days that you can provide. Like it's cumulative, as well as you can't have more than so many consecutive. So,
thank you for correcting me.
Yeah,
I figured I don't know anybody that does it. I just figured theoretically it could be possible. I'm glad for the clarification.
I don't think it aligns with policy or statute. So, not saying it's never happened in Arizona, but it shouldn't be happening. But like with this one, like it's really tough, because like this would be a truly extreme circumstance, and usually it happens less because it's not done as a punishment. It's typically done for the life safety of the other students on campus. So, as far as whether we allow for credit for that quarter or not, like I'd rather err on the side of, if the kids completed enough coursework to earn credit, why not provide the kid with the credit? Because if perhaps they get help someplace, and then they're less far behind, like setting them further behind isn't going to help them have a better outcome down the line.
Right.
But I don't know how you capture that. So, they're talking about more than 20 days within a quarter, and a quarter is typically 8 weeks. So it's roughly 40 days. So they're basically referring to if a kid's missed more than half of that quarter.
Oh, just a clarification. That's what I'm saying. They just literally said if you had it. Yeah, because I was like,
Yeah.
if you had an 11-day long term, that's where. So that's
Yeah.
on me actually. That
Yeah, so yeah, you're right. They had the semester language, and it was like no matter what happened, the 11 days was the semester. But I
Yeah.
personally prefer 20 days within a quarter, because if you were there for less than half of the quarter, you probably shouldn't be getting credit for that. That's going to do you more harm than good, because there's no way that you picked up that content only being there less than half the time.
Can I ask a clarifying question? Especially now that so many of our assignments are in Google Classroom and things like that. And students have access to their work, or they have access to things that are on Seesaw. Do we have to include that part in there? Because I'm thinking about a student that might have a chronic illness that misses a huge chunk of the quarter, or we have some students that have really bad attendance that might miss maybe not quite that much, but quite a bit of the quarter. So do we have to include that language, and we can just take it on a case-by-case basis? And I
Well,
think
this
the
is
reason
just for
why-
suspensions.
Yeah, this is just suspension, not illness.
No, I'm saying, I'm sorry, let me clarify. I'm likening it to a child that might be out for a longer period, but I'm talking about for a student that might be, we have students that just have quite a bit of absences, unfortunately. That's why it's one of our guardrails, but that missed quite a bit of the school year. So do we have to have that part in there?
I hear you. I hear what you're saying, but to play devil's advocate, I think of this as, and those other kids should have the same, but this is the logical consequence. Like, if you have to have been making some like serious, this is not a learning poor choice.
Yeah.
This is a big poor choice. And like, this is the worst example, but it's kind of like, if you decide to get in a fight and you get beat up, like that's the logical consequence of doing that. I kind of think like losing credit is a logical consequence which is, I don't care if we take it out, but I don't think we should take it out solely because kids whose parents don't bring them to school can still get credit, I guess, is ultimately where I'm at. Because I do think like, what in the world did you do where we were able to justify in a hearing that you should not be at school for more than 20 days?
Yeah, and I totally hear what you're saying, because I feel like it has happened so infrequently, which is why we can remember, is there a form? Is there not a form? Because we haven't done it in so long. And I think that's because we've gotten like more aware and more proactive and more teaching and more restorative practices, that it happens like so infrequently. But I guess I'm not opposed to keeping it in there. I just don't know what the correct answer is to have it.
We could do, this might be opening up a can of worms, but I feel like this would be fair, is if we said something, we had some sort of language that was like a family like can appeal to, let me say it messy. What if like, okay, if the kid can prove, hey, during this time I was like actively, productively willing to work on Google Classroom and get this done, or like complete this project, then if they do those extra things, they could still get the credit. But you don't just automatically get an opportunity to get credit just because.
Sorry, Katie has double hands raised.
Oh,
So
I
if you notice, the next section is readmission procedures, right? So I think I think what you're getting at to me is like, if somebody's been long-term suspended after 5 days, if they're that eager to get back to school and get back to work, they have a procedure to come back, or at least apply for it. Doesn't matter if it's 20-day suspension or semester suspension. As long as it's more than 10 days and they've served 5 of that, they can apply for readmission. So, and that doesn't mean they're going to get approved, but it's a way to try to show that you're wanting to get back to school, and there's going to be some sort of application process for that.
May I make a suggestion?
Only kinder.
And then the only other thing I was going to say was, sorry, just really quick. I've already lost my thought on the other thing, which is that even just a reminder, like we've said this year by year, but even if it's not the practice to have like a 10-day or a 14-day suspension or something like that, It's usually either small or big, really big. I think we need to keep the opportunities open for that for the future. We're not trying to limit things here just because it's not our practice right now. We don't know what people are going to do in the future. And so I would say this language, I feel like still does that. So I wouldn't want to limit it anymore just because we don't necessarily see like 11-day suspensions very often or something like that.
Mm-hmm. What were you gonna say, James?
So normally I'm not a big fan of any kind of policy that is what I consider like fluff. But I think my suggestion basically is to keep it in. But I always feel like there should be some nuance. That it reminds me of like the time period where they had the 3 strikes and you're out laws, right? Where the judges had very little ability to see the individual situation and make a decision on that. They were just locked into it because that was the hardness of the law that was passed. But with this one, could it be just as simple as the student may receive no credit for the quarter during which the long-term suspension is imposed? The language is still there, but it also opens it up to the possibility of like saying, you can have the obviously people at the district level, because this would not be solely a site level thing, but people at the district level, that they're not locked into it, like no matter what, you will receive no credit. It allows a little bit of flexibility.
I think in order to do that, you would need to change the thing before it too, because if you're going to allow credit, they need to do something to get the credit. So if they're missing more than 20 days, then you can't have it say no course assignments will be provided.
Oh, that's
Agreed.
Didn't we use
I
to
worry a
provide
little bit
that?
if we, sorry, I worry a little bit if we do that, like change to say they might get credit or they might not get credit, then we'll have, I don't know, just imagine a situation where my family at Kennedy says, whoa, I heard from a family over at Monte Vista that they did get credit. And like, I don't know. I just see like an opportunity for families who are possibly already upset to be more upset if it's not like very fair or equitable.
I feel like I'm not usually this person. I usually am like, let's be alongside them. I'm kind of like, no, you're done. So like whatever you did to get more than 20 days, that's it. So I'm good with whatever we want to do. But I do feel like what you're saying, I was like, yes, James, that sounds great. And then I was like, oh, that's a good point. So now I'm like, no, they're just there. It's not enough. Let's not be gray, but also there has to be, I don't know. I think it's such a logical consequence for having done whatever you did to get to this point. It feels not life lesson to get the credit, which is not rare. That's a rare feeling for me. So I could be easily persuaded otherwise.
Usually you're the
I have-
super kind one.
I have no hill to die on.
I leave it to
Not
you.
that you're unkind. Sorry, I shouldn't say that.
No,
but
no,
just,
I know.
you're usually like the very like, and I'm the one that's like,
I know, that's what I'm saying. I'm like, I'm not sure why. I'm like, no. But I guess in my mind, a 20-day suspension, if I was willing to give a kid a 20-day suspension, they basically like beat somebody to like the brink. You know what I mean? Or like they had a major crime ring or something. I just don't, I don't know. Evan, what do you think?
No, I agree. I mean, I don't know. This is only year 2 for me, but I was at, Mackin for much longer, and I don't know of a single kid who was suspended for that long in all that time. So I just feel like this is so rare that the act would have been very egregious, like you're saying. And so I do feel like it's fair to say if you're gone for this much time, then you would not get credit, akin to what Amy was saying with like the kids who are out for so many days for health concerns or whatever. Like if you're not here, are you getting credit? I don't know. I think I would say no. Let's just leave it with the 20 days within a quarter.
Okay.
Yeah.
The-
Having
the-
gone through that not too long ago, I can tell you, like for me, um, because I did feel empathy towards the situation, but at the end of the day, uh, it was more important in my mind to protect the community and the culture of the students that we teach right now. And I'm not saying that it's not important to do that with a student that has made a poor choice, but um, it did make me a little bit more comfortable with the severity of the consequence.
Okay. Okay. Well, then, in that instance, I'm gonna put this one down as completed, and then
Adriana, if I
Yeah,
could just say one more thing.
Yeah.
I do get nervous when we lock ourselves into something rather than having leeway, because there are unique and individual circumstances to every case.
Okay.
And so I don't know. I mean, I think if there's room to have some leeway there, or to even have it be through an appeal process, um, that I don't think, again, as Katie said, somebody else might be superintendent. But for me, chances are the only reason I would go against the decision that's coming from the school is if new information came forward, and I would have a conversation with the leadership of the school and say, hey, we discovered this and this is what's happening, and there's a legitimate reason for why we might want to have more clemency with this child, or to prevent some other harm from being done. So I'm just putting that out there.
then if okay, hold on. I've lost the page, and I didn't put page numbers on this one either. So then do you want to do like a clause where it was like the appeal on the right part? Yeah, suspensions.
Could we say something about like left up to the district's discretion?
Yeah, I think right now what it actually says is that no appeal is possible for the short term. There is an appeals process built into long term.
So then okay, so should I go up
Oh
to
wait, there's a readmissions procedure already at the bottom. That's what Katie was talking about.
Yeah, but that
Only for the little kids though. So do we need to add something for the 5th through 12th? Or I
This
guess
whole, this
but
whole
readmitted is different from credit to their because readmitted is like you just get to like cut your suspension short and go back to class.
true.
We're talking about like basically reapplying for the work that you missed. No?
but that would like the readmission for a K4 would negate the other one, right? Because
It
you
would
get apply for that after 5 days. So it would
Yeah.
effectively cancel that loss of the consequence of losing your credit. That's really
That's what I was trying to say earlier, but you're explaining it better. But also you could get denied. And then you would still be in the same situation, I guess.
Yeah.
So should we add something to this part about the last paragraph, 5th through, should we change this to 8th grade student who's been long-term? Like, not that they could be readmitted, but that they could, I don't
Oh,
know.
I see. You're just saying, yeah, because I was like, I don't think that they should be like, you know what, I really made amends in those 5 days. But you're saying like, but here, like you're basically like you're not, it's not a readmission, but you're like reapplying for the credit.
Something
that you could get the credit. I think that would be I feel like it would still need to be above F. It still needs to be within, or maybe we just change the title. You're saying something like
Well, because on E, maybe what we need to change is where it says that they don't receive credit. Because for E, it's talking about restrictions. So they can't be on school property. They can't participate in school function events. They also don't get assignments. Well, maybe that is part of the restriction, is that they don't get credit. Never mind.
I know I was saying the same thing. I was like, oh, let me delete what I was saying. Okay. So
I
Mm,
added
will.
page numbers to the document.
struggling. Is it they may reappeal? They may to like. I basically want to say that a student could see if they can get the credit in some sort of process, but I can't think of a way to say that.
Maybe something like a student may request reinstatement
Of credit.
of credit.
Hmm.
If,
Do an appeals process, and then
yeah.
we can.
Like in completion of work.
In my mind, yeah. In
Like
my
you-
mind, we would have like an application or something, right? That would be like, here's what you can apply, and like here would be the like work that you would need to get done in order to do so.
like you can't just apply, but you actually have to do the work in order to get the credit.
Okay. Yeah. I'm like just putting words together, everybody. How's this? I'm not sure if this is what we meant. If you can look, I will put it in red.
I think that sounds really good.
Yeah.
Okay. James, you good with that?
Yeah.
All right. So then,
Just from a grammar perspective,
Yeah.
Or would capture and then you can avoid what they used to refer to in
like,
school as the dreaded and or.
okay. Got it. All right. So then I think that's the end of that one. So let me go back. So the next one is the staff interviews of students and searches, but it sounded like we wanted like 10 minutes or so to kind of go through it. Is that right? Looks like Amy already went through. Oh, it's really short. Do you want to just take like 5 minutes to read through it and see if actually, sorry, do you guys it's so short. Why don't we just go through the comments, and then Evan, if you feel like you want like 5 or 6 minutes to like review, just let us know. Does that work for everybody?
Yeah, that sounds good.
Okay. So I can't see any of you because I can't have so if you're nodding at me or whatever, I'm probably just looking blankly at my screen. So just so you know, in order for me to move it for us in the display, I have to be on a different window. Okay, so wait, clarity on what is seriousness.
Wait, is this 5304 we're looking at, or 306B?
304.
Did we do? I think we did. Oh no, we're on. We didn't do 306B. That's the next one. You're right.
That one's also, well, maybe
Because
it's
it's
not.
all. It's just expulsion stuff.
Yeah.
The expulsion stuff is almost verbatim. The exact same thing as the suspension stuff, except it just says expulsion in lieu of,
Yeah.
it says expulsion in lieu of suspension, but it's almost identical.
Mm.
Why don't we do like 5 minute? I think you're right. Because I didn't even bother looking at this one because that's what it was like last year on the old ones. You do have. Oh, was this the same question that you had on the?
Yeah, ignore it.
Okay.
But you are still projecting, are we doing 304 or are we doing the expulsion one?
I was gonna finish through expulsion. Sorry, so that
Okay.
with the. Do you see it now?
Yeah,
Okay. Thank you.
I know it doesn't automatically.
I know it's. Do we? I don't. On the section 2 written notice of expulsion hearing, it has in for 2I, it says the parents have to give the district at least 2 working days prior to know if the student will be represented by legal counsel. Do we feel like we need more time than that? Like, wouldn't it take us more than 2 days to get our legal counsel there, or do we not need them?
I've been told anytime that there is a lawyer to ensure that we have our district legal counsel present.
That's what I thought too. Should we do 5 like we do for what was that 5 for in the suspension one? It was like we were giving the parent 5 days.
As long as like it aligns with state statute, I don't know the law around that, so.
I'm pretty
Actually.
confident that's driven by statute in the 10-day window.
Okay, no, never mind then.
My only, yeah, and I was gonna say my only concern, and I think why they probably put it shorter is that, you know, it costs money and you may have to get money scrounged up
Got it.
quickly.
All right. So I read through it and I don't have any more comments. So if we want to just, whenever you guys are done, if you've got like, let us know.
I'm done as well. I didn't see anything either. Except this is a couple times through 12th grade, and I know we only go till 8th. I don't know if we need to change that or not. The other one said it as well.
I don't know. I don't remember what we did it previously. I think when we copy it from the statute, we didn't change it at all, but I don't remember.
I don't know that it matters, but everything else seemed logical.
Same.
Same for me too.
Same.
Okay, cool. Then I'm gonna go ahead and say that we did finish this one. And then now I'm going to 5 through 4 staff interviews of students and searches. And then my first comment was just on, depending on the seriousness, feels real subjective. So I didn't know if it was one of those things where it's good to keep the seriousness like kind of nebulous like that because there's so many like variations of things, or if we wanted to add clarity to that. And then also, Amy answered my comment, but we have parents who are like, you can't speak to my student about anything unless I'm present in the room, even though that's not necessarily true. So I feel like, should we include that in the policy? Those were my 2 questions for the group.
Say that one more time. I'm so sorry.
No, you're good. Okay, so that first line, will be contacted regarding an interview of their student, depending on the seriousness of the
Oh, yeah.
offense. I feel like depending on the seriousness of offense is like very nebulous, which there's probably pros and cons for both. So I wasn't sure. Do we want to stick with that? And the second part to that is we get not a lot. I have one family who pushes back about how we can't talk to their child without them there, even if their child is like the one who's like saying that they're like a victim of something, and it makes it really challenging. So I was wondering, should we include, well, actually, no, we are able to speak to your student without the parent.
I've had that happen as well.
Me too, several times. I agree.
And typically we don't really notify the parent or guardian until after we've talked to the child or the investigation. It's because, you know, if we're going to call the parent and notify them beforehand, we're not going to be able to give them any of the information. And usually you don't find out exactly what happened until you've talked to multiple parties, and sometimes multiple times. And we won't necessarily have the answers to questions that parents or guardians will have until we speak with that child.
And then the same thing is what Amy added like to that is also, is this talking about students who are interviewed? Like, do we want, like, I'm sorry, interviewed as witnesses? Like, are we contacting them? Which we don't typically contact students who are witnesses unless if we like,
unless there's like a concern about something.
Yeah.
Like if they, you know, something were to happen on the playground and they just happen to be a witness, we don't typically contact the witness's parents, especially if it's, you know, there's 15 witnesses.
Yeah. And that kind of is like depending on the seriousness. Cause I know when, like, if we talk to kids about like, if they were involved in a vape situation, we usually will call then, just cause we don't want parents thinking that we're like
100%
casually about drugs. So like, that is like those ones we would call. So I just don't know. I don't know. Now I'm talking myself out of it. Maybe depending on seriousness is the best way to go about it because it's so nuanced. But I do feel like we need a line that's like, or maybe this is kind of what James was saying, may be contacted instead of will be contacted. And then something about like the district, like, I don't know, reserves the right to speak to students. I don't know how to say it.
What, can I ask a question, Adriana? What's your response to the parent?
We well, actually, I'm gonna be very honest. I was like, oh, geez, okay. And so we've been like following that. And then it just got like, and then I learned that was not the best idea because their student happens to get into a lot of trouble. And so it was actually making like a hindrance. So now we've just let her know, like, actually, that was like out of courtesy, but the reality is we can speak to your student before. So now we tell parents, like, we appreciate that. And we're still going to talk to your student.
Gotcha.
Amy actually helped me out with that one, gave me much better verbiage than I just used right now. But yeah, we're not doing that anymore.
Yeah, I heard the phrase in loco parentis. That was a phrase that was always mentioned to me.
Yeah. Okay. So just to start again, are we good with instead of will be, we put may be contacted?
I think maybe is fine.
Okay. And then does anyone want to take a stab at writing the oh wait, it's up here. I just remembered. The broad authority to question students regarding if we just put here prior to any parent notification. Could we put just like that?
It's interesting that that first sentence, kind of the way it was originally written, appears to me to contradict the second one. So
I know.
it says may have broad authority, and then it says we will contact you. That seems.
Yeah. Well, do you think this sentence was supposed to be just like regarding the offender?
Well, I mean, the way I read that first sentence is that it's you're conducting an investigation. So, like your authority to question students.
Yeah.
That's how I read it as well. That's why I was like, well, no, not actually.
Yeah. Okay, so okay, I just added like two kind of like nuances to both in bright purple. Will you guys look at it and tell me what you think? Magenta.
Okay, so I see student is in blue. I'm just making sure, it's but the S is in black. So is the S added just now?
No, it's because I for some reason had student highlighted, so it highlighted all in blue when I copied and pasted the whole thing, and I just didn't change it. So all of those student blues is just because when I was copying it, I had them highlighted.
So it originally said students and then student with an S in parentheses on the other line?
Yeah.
Oh, okay. Okay. I was like, interesting. All right.
I don't know why it did that. And then last meeting, I was like, oh, I should go and fix that. And I just didn't. But the stuff in purple, I just added.
Can I ask why you added that?
Well, I think because we have a broad authority to question students prior to their notification. I just wanted it like crystal clear. Like before I talk to you, I may have talked to your kid. And then here, their child's role in the situation, that resolves the witness thing. So like if your kid was a witness, I may not reach out to them because their role wasn't anything.
Sorry, I don't mean to do this, but maybe this is for Jay. My lawyer brain isn't liking how that's written before, and I know it's not what Adriana wrote, but So it says have the broad authority to question students generally. Later on, it says prohibited or illegal activity in all matters involving the health, safety, and welfare of the student. Parentheses S. To me, at the end, that's implying the health, safety, and welfare of specific students, versus the beginning, you can broadly question all students. So there could be an argument that parent notification would need to be made if it wasn't involving the health, safety, and welfare of specific students that are involved in whatever it is, if you're reading this properly legally.
Yeah.
But I don't know who wrote this, and so that's what was throwing me off. Sorry.
Yeah, and I think that portion came with it, because I think Adriana just added the purple.
Yeah, I know that.
So I, you know, I don't know if it solves it, Katie, to put the S on the first students in parentheses, or if that still leaves it gray.
I just think it's the word "the" that messes up the end, right?
Oh,
Because you're
yeah.
specifying the student or the student.
Why don't we make it? Yeah, why don't we just take the away?
Just of student of, well, because of student. I don't know what.
Well, then I think we need to just make it plural.
Of students, and then get
And the only problem that creates is someone could argue, well, this only affected one student, not multiple students, so therefore you didn't have this authority. So
yeah, I mean, I don't like that either, so I don't know.
I don't know.
I've seen it done as a student where the S is in parentheses, but I don't know if that gets around the problem or not.
Yeah, I think it still then makes it specifically about, you're going to have arguments either way with both versions. So I don't know. I'm sorry.
It's all right. There's nothing to be sorry about. It's dang messy no matter what. Well, not no matter what, but in either of those wordings. Interview of their student depending on this, regarding prohibitive in all matters. And all matters that may affect the health, safety, and welfare of any student.
Yeah, and then that keeps it broad, like you just said, right? And somebody could be like, well, that's pretty crazy. I think that makes it even more broad than it was before. Like, basically, you could question students at any time about anything, it feels like.
Well, I mean, you'd have to be able to make the argument that there was either illegal activity or there was a health, safety, or welfare issue, but it could relate to any student then.
Yeah, no, I get that. I just could see how
it's pretty
a bad
broad.
actor could interpret that how they wanted to.
Yeah, and I'm not trying to poo-poo that, but
yeah,
unfortunately, like,
maybe let's just put it
actors
back
will
the
find
way
a
it
way.
was, because that's what's been legally approved already, and
yeah.
I could ask somebody later on about it. I'm sorry, Adriana. It was just throwing me off.
No, you're good.
And the wording might be bad because somebody else went down this same trail at some point and just decided, you know what, there isn't a solid way to fix this.
Okay. So back to the purple. What are you thinking? Yes, no? I'm amenable to anything. I was just trying to resolve the when will we not call and test parents and the witness thing. So do you want to start with this one? Yay, nay, prior to parent notification with the first paragraph?
I think it sounds okay there to me. I think both of them I would agree with.
Okay. What do you think, Amy and James?
I'm just rereading it one more time.
Okay.
I honestly, it didn't make sense at first, and then when you explained it, now it makes sense.
Okay.
But so I understand it. I guess I'd be curious. I mean, I can't imagine too many people spending their daily lives going through and looking through policy all the time, but I'm sure there are some people that are like that.
I've had a
To
few.
see if they, I'd be curious to see how many people go through the same like thought process I went through.
Adri, oh, you fixed it already. Never mind. I was going to ask for that and to be merged.
Yeah, I was like, what did I do there? Okay. All right, then I am getting rid of these ones. And then the next one is district
Only
employees.
thing, Adriana, I'm sorry. We
No, you're
just
good.
need to go back and put the language back, welfare of, oh, we already did it. It
Yeah, I
didn't
did.
look like it was there before. Sorry.
I don't think it was. I think I realized I was still missing the so I had to keep going back.
Thank you.
No problem. District employees may search students.
That was my like concern. Like we typically, and maybe this is just a practice, but I thought it was only administration.
We've only done administration. Every once in a while we had the office manager do it. Like if Karina and I were both off campus, she would do it with one of the coaches. So, but I also would rather it be like one of those things where it's like the principal or the principal designee as opposed to district employees, because I feel like this is like
That opens it up to anybody and everybody. And
I
it
guess
just,
my question then is like, let's say you are a coach on a trip and you suspect somebody has something in their bag and it's like 6 o'clock or something. Are
I
you
think-
waiting and holding on to the bag until you see a principal, or?
I think wouldn't you call them like a designee though? Wouldn't you like? I think my thing is, so let me finish my sentence. Sorry. I think like in an instance like that, it would be like if there's something you need to go ahead and do it, would be my like practice. I think my worry is I have people who would definitely be like, I'm pretty sure they have something, and just like, yeah.
yeah, I think that's why I would like it to be left up to principal or principal's designee. And then in terms of it, like a principal's designee is like if they were on some kind of trip or something like that, whether it be a field trip and they're not there, that's when you call your administrator. Hey, I like have, this is what's going on. Walk me through what I should be doing. Something on like, we need to check, or you see what I'm saying? I think it, like, and that would be like a
No, yeah,
time
that's
when it would be
fine.
the designee.
Because
But
we
I
have
don't
that
wanna
in
just
the
leave it
rest of the
open.
policies as well, the
Yeah.
designee thing.
I just don't want it to be left open to anybody and everybody, especially like there's certain things you do, you follow a certain process or procedure, and certain things you don't do.
Mm-hmm.
And I
So-
think we
Sorry.
open it up to everybody, that it would just,
I just I'm not a fan of allowing all employees, but I want to give you a quick edge case to think about. Junior ambassador. So now you've got some staff that have a couple of kids from each of the 9 campuses, and an incident occurs. So then do they need to get a hold of all 9 principals to get permission in order to be able to take action to search?
I was a ambassadors person, and so I was not calling people. I was like, show me your bag. So but I feel like that's what going back to the designee.
But I think what Amy's implying is that the designee has at least had contact with the principal. But we don't have a definition of designee anywhere, right?
that would be best
So then
practice.
that's fine. As long as we're not defining designee to make it some strict guideline, then we'll fine still saying principal or designee. It wouldn't require all that.
I don't think we should have, I don't think we should have a strict thing. I just want to, honestly, this is what I want. I want to be able to say to a teacher or to like an aide, you didn't have a right to go to that student's backpack because I didn't like give you that like authority. Because I could see like our teachers want to go through backpacks whenever a kid like loses something. They want to go through the kid's backpack that they all think it is. So, yeah, I would want to keep it really broad so that we could like handle those circumstances, but also make it very clear you needed to have permission before you did this.
And quite frankly, I don't ever want to reach my hand into a kid's backpack and have to go through it. Those things are gross. So I usually always, anytime I would search a bag, I would be like, look, I'm going to go through your bag. Is there going to be anything in here that I will find that I shouldn't find? Because I would much rather you just show me now, as long as it wasn't a safety concern. I was like, and usually they're like, here you go, miss. I was like, thank you.
Here's what I'm thinking about saying, and then what about people who are above us or not at our sites? So like, are we doing something where now like Sarah Beth's on campus and she like needs to search a kid? Are we
Or do we designate, I guess?
still a
When I
designee?
read administration, I don't think of principal. I think of the
Yeah,
district.
well,
the
we had a
district policy.
situation like at Kennedy where Julie was on campus and she was helping with something, but I felt like in that moment she was acting as the designee, like the principal.
Okay.
I guess when I'm reading this, because these are district-wide policies, when I read administration, I don't think of it as a school level thing. I think of it as a district-wide. Everyone that works at the office, to me, is an administrator that works at the district office.
Okay.
Anyway, like in my mind. And so reading that, I would think it would apply to anyone who's not at a site and then site or who they've chosen.
Okay. Okay. So then that clears it then. Are
Is
we good
this, does this also, going along the same lines of what Adriana was talking about, interviewing a kid, does a parent have the ability to say, no, you can't search my child?
So on here, I think it's an or. So I think it's like, so I think that a parent can't tell us we can't search. This is how I read that policy.
Correct.
Correct.
But
Okay.
if you don't have reasonable suspicion and you want to search and they give consent, then you can search, which they should never do that.
They usually don't.
Good for them.
I wish it was the social activists that were the ones that were not giving consent, though. That would make my heart much better off. Sadly, the ones that know the law the best are the ones that tend to be the ones who break the law.
Okay. Are we good with this one?
Yeah.
All right. So it's 5:54, so I think we would need to hold on the next two. So let's start talking about homework and next meetings, if that works for everybody. Yep. Okay. So I think we did schedule one more meeting, Hilda, and I know we said we were going to wait till after the new year, but we
Yes, we scheduled one for December 16th. A
Okay.
virtual. And you should have a calendar invite.
all right.
December 16th? What were we thinking?
You weren't present.
Oh,
I wish that I were. Who thought that was a good idea?
So you get for missing a meeting, James.
What time is the
Dang it.
one on the 16th, by the way?
4:30
Oh, it's at 4:32. Okay. And is it virtual or in person?
virtual.
Okay.
Okay, does that still work for everybody?
I guess.
Okay.
Wait, I'm
next-
sorry. When was it again? I do have it on my calendar, but it's on the 16th. correct? Okay.
December 16th.
Okay.
That's just mean-spirited.
I mean, we didn't do it for the 18th at like 4:00.
That's true.
That
That
would be
that
horrible.
be mean.
Okay, so then we have two more to finish. Actually, sorry, let me see. Yeah, so we have two more. I think maybe we need to like pick the next policy and add those as like things to review, if that's okay with everybody. And then I think we should be good to go. Sorry, it's taking me a second to get through everything. Okay, are you guys looking now out the completed policies checklist. Is that what sharing now?
Yes.
Okay.
I don't know if I have that document.
If you go into the 25-26 editing, policy editing folder, you should see it there. But I think
Okay,
I
thank
also attached it to the rolling agenda. No problem.
Okay, perfect. Thank you.
And I think James has his hand up.
Oh, sorry, James, go ahead. I can't, sorry.
I do? Oh,
Do
sorry.
you? You
I
had your
must-
hand up.
I must have tapped something that I didn't intend to. How do I get it down?
No,
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 your
no. You had
actual
your
hand.
actual hand up.
Oh, no, I was scratching my head.
Oh,
Okay. Did we do, we've already gotten through student concerns, complaints, and grievances. So I think we have the now are these secret society, gang activity, and hazing. Or removal of a student from a school-sponsored activity. Do you guys have a preference on what is covered? Something that you feel like is covered more? Or like happens more?
I'm just wondering if we should do school-sponsored activity one.
Okay. And then I gotta go. Because that form that you guys are looking at right now, it doesn't have like the crosswalk for each of them, so I gotta figure out which one it is. Actually, sorry, I'm going to share this tab instead. I'm not quite sure. I don't see it. I think it might be different how they have things organized. Is there?
what is it called?
Well, the one that she was saying was the removal from school sponsored activities, but I don't know where that would fall in here.
Hmm.
So did we look at this prohibition on harassment, intimidation, and bullying? Oh, is it that?
I swear we did last year, but I feel like I have deja vu, or I guess this is year 3. I have deja vu on everything at this point.
I thought we looked at it something similar this year, like, or maybe it was just harassment
Oh,
that we
no.
had a long conversation about.
Yeah. This one's done because I remember we had put like threat and intimidation. This is like a very long order we worked on last year. Okay.
I'm doing a search, but it's taking forever.
Yeah. I think.
Do you want to try 5202?
202.
No, that's not it. That's not it. That's
Oh wait, requirements relating to participation. 213. It might be 213.
Yeah, probably.
yes, 213.
Oh, the heck.
I know. Okay, maybe look at
Maybe it's the one after that.
2A. No.
That's funny.
Well, 213A is the one that
Yeah.
says district sponsored activities.
Okay.
Well, yeah, the first one was the actual policy, and this is I forget what
The
they call this
procedure.
now.
Procedure, yeah.
All right. So then why don't we do for like the homework 5213A.
Where was, could you go back to the list of stuff we haven't looked at yet? I'm sorry.
Yeah, it's hard though, because, okay, so here's the oh, sorry, I forgot to share.
Sorry.
Is it shared now? Yeah.
Yeah.
So, these are all the old policies, but they're like stuff. Because they haven't done secret societies and gang activity, but I don't even see it in that list.
No, I know it's in another policy though, is the thing that I recall. Do you remember, Jay? I feel like I looked it up last time. Hold on.
I'm trying to remember, but it was in the, it was in,
Oh yeah, you can quick search this manual.
because there's two of them. There's one in the 5s that's related to students, and there's one in another section that's related to parents and community.
Okay, so there's one, the gang stuff is in 5301, which is student freedom of expression, and then 5305A under the student conduct, there's some gang stuff in there.
So what if we did the first one you said, 301, and then the 213? Because we still have like two search and seizure, like the police and DCS anyway. So all you would be doing is just reviewing these for like questions you have.
Okay, 301, that's not, no, sorry, 301 is not right, because it's like, oh, what the heck is this? Procedure. Okay. I think we should look at, instead of 301, we should look at 305A, which is the student code of conduct.
I think we did that one already though.
We did A and not the actual, just the policy.
Let me look.
It like lists out all this stuff.
So I think that one was the one that 30. Wait, which one? 5 what?
305A.
I think this was.
Let me go back to that. And then removal of students from school, expulsion of students receiving from the corporal
Yeah, this is
punishment.
different. We didn't do this one. We didn't do the procedure. We only did the policy.
Okay. Because, yeah, when I looked at 301, that wasn't something we need to look at. It was some basic thing. That's fine. It was like kind of the last one we looked at.
Okay.
Jay, are we certain that like the new student attire policy conforms to like the unique stuff we had in our previous one? Because I know that was a big deal the first year we had this committee, but I'm not sure if everything transferred over.
My understanding was that it had, but we could take a look again. It was supposed to be crosswalked, but I don't recall specifically having verified it myself.
Okay. Well, we don't need to go back over it as a committee again. That's okay. I'm looking at it now. It seems okay.
Like, I think where we landed was we had a process for change, but we also had a review period. Is the review period still there?
Let me look. Review. It just says the principal of each school shall follow up with staff and parents to review school guidelines for student dress, and that's under the adoption of school uniforms part of the policy, but there's no like review period thing that's outlined.
Yeah, what I meant was like that there's a cycle for coming back to review it again. So
so maybe if there was something outlined like that, then no, it wasn't.
it may not have made it. So
It didn't make it.
We can grab what we had and bring it back for this group to just crosswalk. So
Okay, so that's 5302 is the student.
5302. Okay.
Mhm.
I'm gonna write that.
And then let me go back and make sure we can look at the corporal punishment stuff really quick because I just want to make sure too.
We didn't look at that at all.
Yeah. Let's see where it's listed. Oh, that's in student discipline 5306. Did we already do 5306?
Let me see.
Sorry. I know we did that last week, maybe.
Yeah.
Okay, and we said the district does not permit the use of corporal punishment. All right, cool. Awesome. So I think we're good on that. then.
Okay. So then what I have based on
For JKA, we're solid. We don't need to do anything else.
so we have was 302 the dress code?
Student tire,
Sorry,
yeah.
just listening to student type. Okay, so if you probably already looked at 401 and 402 because we were supposed to do it for this one, but then I just added these two and then our bonus one here. Does that look okay in terms of before our next meeting? Or do we want to, do you want to adjust and have like move student attire down the bonus?
Well, I feel like student attire won't take very long if we take what we did. I know we have a document somewhere, right?
Yeah.
We just have to copy and paste into it, so it shouldn't take very long. And I don't really think it needs to be homework necessarily, so long as we just take a look at maybe what's missing during the meeting.
You know what?
Open it up.
It's there, Katie.
It
I'm
is?
looking-
Did I not
I'm-
see it?
I'm looking at it right now. It's in the first paragraph.
Oh, that's weird. I guess I was looking for the words review maybe and not.
Well, that was my fault because I was working from memory.
Yeah, sorry.
It said it says the principal of each school shall meet with staff and parent representatives to develop school guidelines for dress. If you can actually speak the English
Once at least every 5 years.
5
Okay.
years, and that was what we added to make sure that you didn't like either put a dress like a unpopular dress code in place and it just sat forever because it had inertia, or like a lot of it had to do with uniform.
Outdated stuff too. Like
Yeah.
we had all that outdated stuff in here. Okay,
Yeah,
sorry. All right, so we can take it off. Sorry.
Yeah, no, you're fine. I thought they had crosswalked it, but I wanted to double check it. So
And Jay, if you notice, it's not copyrighted, so it was crosswalked.
Oh, thank you.
yeah, that's usually a pretty good giveaway. If you notice the copyrights off of it, it means that
Sorry.
it had great revisions. No, it's all good.
Okay. All right. So then this will be the homework. I am ready to be done for today, but I can get these like copied and pasted if you guys, does anyone plan on doing that before Friday? And then I will make sure that it's on there. So if you wanted some Saturday morning work, the new documents will be linked in there. And then we should be good. Does that work for everybody?
Sounds good.
Okay. So can I get a motion to adjourn the meeting?
I motion to adjourn.
Okay. I'll second. All those in favor? Aye.
Aye.
All right.
Thank you, everybody.
Bye, everybody. Have a good rest of the day.
Thank you all.
Good night.
Aye.
Can I leave?